My Lords, if there's one thing I've heard time and time again during the passage of this bill, and from the government front bench, is this is a bill to streamline the obstacles for anybody who wants to get anything done in this country. And that's what Amendment 208 does, which I support entirely. Just under 2 weeks ago, as my noble friend, the Lord Roper, mentioned, in the Supreme Court, 4 years of litigation concluded in the Fry case, and the case revolved around the protections of Ramsar sites. In essence, the court was asked to judge whether Ramsar sites were subject to the same onerous requirements as sites protected by the EU Habitats Directorate, including the potential for developments to be blocked at the stage of discharging planning conditions, many years after they have obtained that planning permission. Now, for over 50 years, since 1971, when the Ramsar Treaty relating to over 2,500 wetlands in 172 nations was signed in the town of Ramsar, in modern-day Iran, it has never been the case that EU Habitats Directorates apply to these important places. For that period, over the entire world, Ramsar sites have been protected without any reference to the EU, to EU regulations, or any other of the state paraphernalia that flows from Brussels. And why would they be? Because there are 23 such sites in Brazil, 6 in Cameroon, 1 in Mongolia, 3 in Equatorial Guinea, and 39 in Japan. The EU is irrelevant to these places. Well, Natural England, as the government's statutory advisor, quite wrongly asserted that EU habitats regulations were relevant, when they're not. Don't take my word for it. Take the word of the Supreme Court. They concluded that the regulator had no business in making the equivalence between Ramsar and the other nature sites which are covered by the Habitats Directorate. The Supreme Court held that Ramsar sites were not subject to this level of protection as they fell outside the Habitats Directorate. So 12 days ago, a regulatory burden was lifted. Now, inexplicably, the government now seeks to undo that pro-growth judgment by bringing the Ramsar sites back within the habitats regulations, even though they fall outside the regulation's parent directive. So we need a moment to see what's happened here. The justices concluded that Natural England had overreached themselves in their advice to government, that they couldn't interpret the legislation accurately, they misdirected themselves, and crucially misadvised the entire development industry as to the truth. Natural England's dossier had the effect of holding up tens of thousands of homes. The evidence before the court in the Fry case was that 18,000 homes had been held up in Somerset alone, many already with planning permission, owing to Natural England's misplaced concerns. Now, the economic consequences have been crippling. Housing affordability is worsening. The scientific analysis behind their objections remains questionable, and I know that from their approach to nutrient neutrality in Norfolk. In effect, a global treaty was used to gold-plate EU legislation when it had no business of doing so in the UK. And that's not me saying it. That's what the Supreme Court found. Natural England got it wrong. Badly wrong. And even when they had the chance to throw in the towel and admit their mistake, they pressed on for 4 years. Now, so let's get this right. The quango that government tells us could be trusted to get Britain again building is exposed as a blocker, not a builder, not as a matter of opinion, but as a matter of law. Now, that's not to say there should be no regulation at all. In fact, quite the reverse. We on these benches believe strongly that Ramsar sites should be protected, as they currently are in government policy under paragraph 194 of the National Planning Policy Framework, subject to the ordinary principles of planning law. It's just that this organisation that will be simultaneously the advisor, regulator, operator, price setter, enforcer and promoter of all the EDPs contemplated by Part 3 of this bill is making a complete horlicks of it again. Tens of thousands of homes, quite unnecessarily and wrongly, have been held up, and fewer affordable homes have been built, especially in the rural communities that need them most, because Natural England lacked the competence and professionalism to read, interpret and advise ministers on the regulations properly. But with that court case to hand, you would have imagined that the government would have been delighted with the court's decision. They're the ones who keep saying we need to sweep away all the gold plating of the regulations that holds back growth. The government tells us They have chosen a path to lower regulation. By this bill, they have sought to persuade the OBR that they are sincere in this aim. But what's this? Within an hour of the Supreme Court's decision, the Treasury's own solicitors were boasting online that they were going to reapply the gold plate that had been summarily removed by the court justices with the implementation of Clause 90. My lords, they have kidded the public and the press that they are interested in sweeping away bureaucracy. Instead, they are lard on ever more regulation and delay. So I invite those members of this House to support this amendment, in line with the judgment of our learned friends, to agree that we already have all the protections we need for Ramsar sites in the NPPF. And here's the important thing. For the UK to be consistent with our treaty obligations and the custom and practice by all the other 172 global signatories to the Ramsar Convention from all around the world. We should not be an outlier in this, yet that's what the government is intending by its own Clause 90. My lords, the Prime Minister tells us he wants to follow international treaties and the international law. Yeah, if he hasn't said it once, he said it 100 times. Now, both the treaty and the law aren't clear. Clause 90 isn't needed. So let's see whether his government is a builder or a blocker, whether they are sincere about streamlining regulations or they'll have our economy stuck in the mud.